All right, welcome to part 3, the final portion of our week 3 legal research lecture. Now it's time to turn to our final primary sources of law, and that would be case law, which is going to be our main focus, and also agency decisions. Okay, now we're going to turn to case law. I promise we're getting close to the end. Case law, that's going to be our final major primary source for legal research. Case law is composed of various judicial opinions that interpret constitutions, prior cases, statutes, and regulations. As I noted before, case law is compiled into volumes that are called reporters. Only a very tiny fraction of cases that are decided in the US are actually published in reporters. And that's because many cases don't have any precedential value. So for instance, if Tony Stark sues Captain America because Cap damaged Tony's Iron Man suit, and the court rules that Cap owes Tony a new suit, that's fine for Tony and for Captain America, but it doesn't really have any real meaning for the rest of us. So that decision's not going to be published. However, if the Supreme Court rules that Captain America's actions are constrained by the US Constitution and Bill of Rights, well, that does have an impact on the general public. Because if Cap busts into your apartment without a warrant, nothing he finds can be used against you in a court of law. Similarly, if Congress were to pass a law that makes superheroes financially liable for property damage that they cause, that's meaningful to the general public. So the next time Tony's Iron Man suit malfunctions and crashes through your roof, you know that you can sue Tony under the Federal Superhero Property Damage Liability Act, and Tony's going to have to be responsible for paying for your new roof. And when courts interpret that act, that's meaningful for all of us. So the main federal court reporters are the United States Reports, which is the official reporter for the US Supreme Court decisions, and the Federal Reporter, which is the official reporter for federal circuit court decisions. Circuit courts, again, also known as our federal courts of appeals. Because Supreme Court and circuit court rulings set legal precedents in their jurisdictions, the whole of the United States for the Supreme Court and large sections of the country for courts of appeals, those decisions are worth publishing. There are other official reporters, including the Federal Supplement, which publishes some federal district court opinions, although not a lot of them, because district courts are trial courts, and their outcome is much more important to the parties involved than to the rest of us. There are also unofficial reporters. The Atlantic and the Pacific reporters will publish state Supreme Court decisions and possibly some really important state Court of Appeals decisions. Then there are reporters like the Supreme Court Reporter and the Supreme Court Lawyers Edition, which normally we just call the Lawyers Edition. These mirror the official US reports, but they are not the official reporter. Now, the Lawyers Edition is great for case law research because it's got a lot of annotations and headnotes, and headnotes help attorneys perform legal research by basically providing a list of related topics and cases. You will see headnotes on a variety of websites. They are not just limited to the Lawyers Edition. In any event, when you cite to a court case, you need to include the name of the case, the volume and name of the official court reporter, and the page number where the case starts. If it's a Supreme Court decision, you just need to also put in the year the decision was issued, because we all know that the US reports is for the Supreme Court. Otherwise, you need to include the name of the court. So for instance, like I've got the Fourth Circuit decided a case in 2001. It was published as 440 F3D 625. So volume 440 of the Federal Reporter 3rd edition, and that case starts on page 625. Westlaw and Nexus Uni, both accessible via the Auraria library, are the best and most accurate methods of retrieving case law. I far prefer Westlaw to Nexus Uni. Nexus Uni is a stripped-down version of LexisNexis Academic, which is itself a stripped-down version of LexisNexis, but I am going to cover both here. And if you find yourself without access to Westlaw or Nexus Uni, then your best bet is to just Google the case name. Please don't use websites like FindLaw or LegalZoom for legal research. They are really just not the most reliable source. You can go ahead and use Westlaw and Nexus Uni, obviously, but don't ever cite to them. Don't use the Westlaw citation, don't use the Nexus Uni citation. You always need to cite to the official court reporter, and that official citation will be available on the Westlaw and the Nexus Uni versions. So let's start with Nexus Uni. Again, available via the Auraria library databases. You can either select N and scroll down, or you can search for Lexis with an L. It is embedded within Nexus Uni, and for whatever reason, searching for Nexus or Nexus Uni does not always work. But it is there. So from the Nexus Uni homepage, you can click that drop-down menu near the top left, near all Nexus Uni, and it is going to bring up content collections. And from there, you can select cases. Alternately, from the Nexus Uni homepage, you might see the guided search. There you can also click cases, and it will allow you to select federal or state jurisdiction. If you select state, you can narrow by state. From the Nexus Uni homepage, like I said, you can use the guided search, select cases, and then federal cases, or you can just start typing the case name. For our lecture, I am going to use the Supreme Court case Brown versus Board of Education of Topeka, often just known as Brown v. Board of Ed. It is the 1954 U.S. Supreme Court case, which ruled that racial segregation in public schools is unconstitutional, even if the segregated schools are otherwise equal in quality. Spoiler alert, they were not equal in quality. Separate but equal was never actually a thing in practice. So here, as soon as I typed the first part of Brown v. Board of Ed, results popped up. And I know that I'm looking for a U.S. Supreme Court case, so that first citation looks appropriate. It is a citation from U.S. Reports. So I clicked on that result. Now, rather than searching by case name, you can search by citation. That's going to be important if your case is like Smith versus United States, because there will be a lot of those, and so you're going to need the citation. Just be aware that some search engines are very picky about including the periods in the case reporter names. You can see at the bottom a Nexus Uni comparison. When I searched Brown v. Board of Ed citation 347 U.S. 483, and I included periods in U.S., it worked. But without those periods, Nexus Uni returned no results. So if you get no results, just go ahead and put periods in your citation. So this brings up the Supreme Court opinion, Brown v. Board of Ed, and if I scroll down, I will see headnotes, and then I will see the case summary, which is often called a syllabus, and then finally I will get to the actual opinion. Note that the citation for Brown v. Board of Ed is 347 U.S. 483. That means that the case was the 347th volume of U.S. Reports, and it begins on page 483. Your citations in your memos, you're going to also have to include the date. Now, sometimes a case will get overturned. This happens more frequently at the district court and circuit court or court of appeals levels, but the Supreme Court will overturn its own past decisions on occasion. For instance, Brown v. Board of Ed overturned the 1896 case, Plessy v. Ferguson. When a case has any type of negative subsequent treatment, you will get a Shepard's marker. That's going to be in the form of a yellow triangle or a red octagon next to the case's name. Shepard Citations was created by Frank Shepard, and it provides a list of all of the authorities, so statutes, regulations, other cases, that cite a particular case or statute. So that is what I'm talking about when I talk about Shepard's Citations. So in the case of Brown v. Board of Ed, you will see a little yellow triangle and next to the case name. And then over to the right, you'll see the Shepard's box, Shepard's Citations, and that particular box is advising caution. What this means is that in one or more subsequent cases, Brown v. Board of Ed has received some type of negative treatment. Now, a lot of times it is simply cited in a dissenting opinion. You can safely ignore that. Other times, a portion of the case has actually been called into question or overturned. This is a lot more rare than simply seeing dissenting citations. So typically, if a case is overturned, you are going to see a red octagon. If it is called into question, you will see an orange question mark. So again, Shepard Citations started back in the late 1800s. It remains the most popular citation service for legal research. And again, it indicates how the case that you are currently reading has been treated after it was decided. So here is an example of an overturned case. Plessy v. Ferguson, which found that white and black Americans could have separate but equal accommodations, such as railway cars, schools, and water fountains. You see here that there is that red octagon, which is a warning that this case is no longer good law. If you click Reason for Shepard's Signal, look at the top right there, I've got that in a red box, you'll get a pop-up box that lets you know that Plessy v. Ferguson was overruled by Brown v. Board of Education. So earlier, when the Supreme Court decided Plessy, it said, yeah, separate but equal's fine. And then the Supreme Court changed its mind and in Brown versus Board of Ed said, no, separate but equal violates the Constitution. We are overturning Plessy v. Ferguson. If you were to click Shepardize this document, you can see that under the Shepard's heading on the right-hand side of the screen under all of the different citing decisions. You will get the entire history of decisions that reference Plessy v. Ferguson. Shepardize has become a verb that refers to the process of consulting shepards to see if a case has been overturned or reaffirmed or questioned or even just cited by later cases. Let's go back to Brown v. Board of Ed. From that decision, I clicked the link to Shepardize this document, and what you see on the screen, that's the result. So as you can see, 53 subsequent court cases have distinguished somehow the ruling in Brown versus Board of Education. One court case limited the ruling from Brown, although I'll note that is a district court, which is the lowest level of federal courts. They do not have the authority to overrule the Supreme Court. And you can see that one case criticized Brown v. Board of Ed. But you can also see that 136 cases that came after Brown followed the holding in Brown v. Board of Ed. 444 subsequent cases mentioned it in some type of neutral manner, again, often in a dissenting opinion, which does not have precedential value, and over 2,500 cases just cited to Brown v. Board of Ed. Now, as non-attorneys, I do not expect you to worry about Shepardizing cases. You can just limit yourselves to making sure that a case that you want to rely on has not been overturned. You can also find cases easily on Westlaw. Because Westlaw's user interface isn't all cluttered up, and because Westlaw is entirely for legal research, I actually think it's usually the best method to find a case. So you just click Cases from Westlaw's landing page. This brings up cases organized by federal and state cases, by federal court, by federal circuit, and further below, but not visible here on the screen, by state courts. Again, let's look for Brown v. Board of Ed. I just started typing it in. Notice that the search bar does default to searching for all federal cases. So if you need a state case, you're going to have to change that default. So same as with Nexus Uni, Westlaw returns a number of results. These results are organized by relevance, and in this case, the first result, dated May 17, 1954, that is the case I am looking for. Now, Brown v. Board of Ed is a rare instance where there is a subsequent case with the same name, and yet, even though it's the later case, it's not the one that I need. So if I clicked on the second search result for Brown v. Board of Ed, dated May 31st, 1955, it would then become clear to me that I need to see the case that was decided in 1954. Recall, Brown v. Board of Ed was actually a number of different cases that were combined for the Supreme Court opinion. Because some of those cases arose under different local conditions, the court had to continue to address some of these local problems in some of these individual cases. So this Brown v. Board of Ed is a follow-on case that simply addresses local matters. But if I were to click the correct one, the top result, that brings up the Supreme Court opinion for Brown v. Board of Ed. And if I scroll down, I am going to see, head notes, there's the synopsis, there's the syllabus, and then finally the actual opinion. Note again, citation 347 U.S. 483. That is the correct citation for your assignments. Westlaw also gives you the Supreme Court Reporter, which is not the correct citation for your assignments. Shepardizing in Westlaw is referred to with the term Keysight. That is because Lexis has a copyright on Shepard's name. Keysight in Westlaw accomplishes approximately the same thing as shepardizing a case in Nexus Uni. So in Westlaw, a red flag warns that the case or administrative decision is no longer good law. It's been overturned either entirely or in part. Yellow flag warns of some negative subsequent history, but the case is still good law. Blue striped flag means the case is pending appeal to a higher court. Again, regardless of whether you're using Westlaw or Nexus Uni, the important thing for our purposes is that the case is still good law. So if you don't see a red flag or a red stop sign, then for our purposes, all is well. Here you can just see the result of Brown v. Board of Ed's yellow flag. It's listing some negative direct history and then some negative citing references. Determining a case's subsequent citing history is the rare time where I prefer Nexus Uni, and that is just because Shepard's citations really are the best way to shepardize a case. Now, Cornell, their website, is okay if you want to find historic cases. So here, again, I'm looking for Brown v. Board of Ed. I know it's a Supreme Court decision, so I click that. If I scroll all the way down, you can see that there's a historic. So if I were to click that, I would bring up all of the historic Supreme Court cases, and then I can select a topic. If I select the topic of segregation, I will see first Plessy v. Ferguson, and then I will see Brown v. Board of Education. Now, I like Cornell's site for reading cases, but it's not always that great for searching for cases. Fortunately, if you do a regular Google search, it will most likely bring up the case on Cornell's site. But here's an example of actually searching Cornell's site. I decided to search for Obergefell v. Hodges, the case that made same-sex marriage legal throughout the United States. In this case, I'm lucky because Obergefell is a weird name, and so the case that I want is right at the top of the search result list. Because Cornell's case law search isn't that great, because Nexus Uni can be painful, and because Westlaw is sometimes unavailable, I recommend just using a regular Google search to find some case law. This is one time where regular Google is better than Google Scholar when it comes to legal research. So you can see here, I searched for 347 US 483. That's the citation for Brown v. Board of Ed. Google's results provided a link to the case on Cornell's site, and while Cornell's site is difficult for searching for a case, it's great for reading case law. So Google should automatically take you to the decision and the syllabus for the case. Just make sure that you are in fact on the decision tab. Sometimes you don't need to read the whole case because the syllabus will tell you what you want to know, but you can also scroll down past the syllabus and you will come to the opinion. You can also take a shortcut by simply clicking opinion. You'll see here, Brown v. Board of Ed, the opinion was delivered by Chief Justice Earl Warren. Cornell's website provides the correct page numbers for the case as it is printed in U.S. reports or another official reporter, such as Federal Reporter for U.S. Court of Appeals cases. If you were to go to a law library and you picked up volume 347 of the U.S. reports and you turn to page 486, that is where you would see the start of the opinion in the case of Brown v. Board of Ed. But remember, the actual citation for Brown is 347 U.S. 483, parentheses 1954. So the entirety of the Brown entry in U.S. reports begins on page 483, but the opinion begins on page 486. A Supreme Court opinion always starts with a mention of the justice who delivered the opinion on behalf of the court. Now, if you want to quote language from a court opinion, you've got to cite to the correct page number in U.S. reports. So for instance, if you want to quote the court on the, I'm quoting here, so-called separate but equal doctrine, end quote, you need to cite to page 488. So in that case, the full citation would be 347 U.S. 483, comma, 488. And the short version of that citation, if you have already cited to the case, would be 347 U.S. at 488. Cornell's website does not include the page numbers for any of the unofficial Supreme Court reporters. It doesn't have the Supreme Court reporter or the lawyer's edition. It is only providing U.S. reports. That's the official citation. Hopping back to Nexus Uni, you will see that similar to Cornell, Nexus Uni provides the U.S. reports citation, but it also provides a number of other citations. So here on the screen, the first cited reporter is U.S. Reports. That is our official reporter. Regardless of what platform you are using to find a case, the U.S. Reports citation is the official citation. It is the only one that you should be using in your written assignments for our class. And that is because U.S. Reports is prepared by the government printing office. All of the other reporters that you see listed here are prepared by private entities like Lexis or Thomson Reuters. After the U.S. Reports citation here in Nexus Uni, you will see the unofficial Supreme Court reporter citation. In the rare event that a Supreme Court opinion has not yet been published in U.S. Reports, and that would mean it's a really recent case, you can use the Supreme Court reporter citation. Here on Nexus Uni, that is followed by the unofficial Lawyer's Edition citation, followed by the unofficial Lexis citation, followed by the citation to the American Law Reports, which is kind of like a legal encyclopedia, and finally, an Ohio opinion citation, presumably because the Ohio Supreme Court published a copy of Brown. Again, always cite the official reporter, and for the U.S. Supreme Court, that is U.S. Reports. Now, if you need to cite to a certain page number, So for instance, when referring to a court opinion, and especially when quoting from one, you might need to cite the specific page number where the idea or the quote resides in the official reporter. Here, what you can see on the screen is that Nexus Uni is letting you know that when it uses a single asterisk, it is denoting US reports, the official reporter. As we saw in the Cornell version, the opinion in Brown v. Board of Ed, the opinion starts on page 486 of US reports. Nexus Uni also lets you know that it is giving you page numbers from the other unofficial reporters. These are all designated with multiple asterisks. You can ignore everything with more than one asterisk. Just skip right over it when reading. Do not let it interfere with your flow. Like Nexus Uni, Westlaw provides the US report citation as well as a number of other unofficial citations. Again, the official one, US reports, is listed first, followed by the unofficial but second best choice, the Supreme Court reporter. After that, Westlaw provides citations to ALR, Lawyer's Edition, and the Ohio Opinions. Here is an example of citing to a specific page in a judicial opinion on Westlaw. Unlike Nexus Uni, Westlaw only provides 2 citations throughout the body of the opinion, and that is the official US report citation and the unofficial but second best choice Supreme Court reporter. Again, 1 asterisk indicates the page number in the official US reports, and 2 asterisks indicates the page number in the unofficial Supreme Court reporter. In Westlaw, as with all other sources, you will see that Chief Justice Warren's opinion begins on page 486 of US reports. So now that you've learned all these various methods of locating judicial opinions and how to cite to specific pages, why does it matter? Why bother? Well, throughout this course, you are going to read judicial opinions, or at least portions of them, and you may need to locate opinions for your policy analysis memo, and you'll have to make some decisions on which opinions you want to include. This is where briefing a case becomes valuable. The process of briefing a case teaches you how to effectively read, interpret, and summarize judicial opinions. Additionally, you're going to have to submit 2 case briefs for a grade in this class, and that's another reason why you should know how to brief a case. Now, many cases, judicial opinions, they're lengthy, they're dense, they're detailed, they're often full of legal jargon. So it can take a long time if you have to keep referring back to the case itself. Instead, you brief the case. You distill it to its most important parts in plain English. And those important parts are the basic facts necessary to understand the case, the question before the court, which is called the question of law or the issue of law, the court's ruling, which is called a holding, and the court's explanation of its holding, the reason that the court held as it did, which is called the rationale. Now, as a quick note, the word brief has several meanings in the legal world. Here, we are specifically talking about a case brief, which is separate and distinct from the types of briefs that attorneys file during litigation. Think of case briefs as the flashcards of the legal world. When you study with flashcards, you don't fill them with dense text and quotations. You use as few words as possible, and you put those concepts into your own words. The same is true of a case brief. So the entire point is that it is brief, no more than 1 page, and that it distills the important parts of the judicial opinion into plain English. So you should be writing the case brief entirely in your own words. If a court opinion has a truly historic or truly well-phrased quotation, okay, you can consider quoting it, but really putting the judicial opinion into your own words is important, because that's how you know that you really understand what the court is saying. Okay, so the case brief, it is 4 short sections in plain English. Again, 1 single-spaced page. Your case brief cannot exceed 1 page. And that means that you have to find the very most important parts of the court's opinion. The brief is written in those 4 sections, in your own words, in plain English. Your facts and your rationale sections are going to be the longest parts of your case brief. Your question of law and your holding will be the shortest. Your facts section should provide a quick rundown of the essential and relevant facts. Now, law students might be required to provide procedural history, how the case got to the court that's issuing the current opinion. But you don't need to do that. It takes up a lot of precious space. It doesn't provide much that's meaningful for our purposes. Usually, you don't even need to include names because the point of the case brief is to assist you in learning jurisprudence, not learning about particular players in each and every case. The benefit of case law is that it is generalizable and it is applicable to any person or any entity's conduct after a court issued that ruling. Your question of law section, it should be a single question that can be answered with yes or no. And your holding section should be a single sentence that answers that question, and it should start with a yes or no. The rationale section explains why the court ruled as it did. Much like with the facts section, you are going to need to find only the most important and relevant parts of the majority decision and then explain them in plain English. So you need to find the Goldilocks zone for your question of law. Also your holding, but if you get the question, you'll have the holding. This can take some practice. So you don't want to be too general and you don't want to be too vague because you need to show that you understand the question before the court and you need that case brief to be helpful to you later. But you also don't want to be too complicated, or you might as well just reread the case. Remember, you want to use case briefs like flashcards. So let's take the case of Miranda versus Arizona, from which we get our Miranda warnings, such as the right to remain silent. If you're briefing this case, a question like, was the police officer's action unconstitutional, is so vague that it's basically meaningless. Like, what action? What part of the Constitution was affected? On the other hand, you don't want to be overly complicated. If you find that your question is spilling over into many different lines, or you're referencing historical developments, or you're using legal jargon, it's too much. You want to aim for just right. And in the case of Miranda v. Arizona, that could be, does the Fifth Amendment require that the government notify arrested or detained individuals of their constitutional right against self-incrimination and their constitutional right to an attorney before the government interrogates them? From this question, you know which portions of the Constitution were triggered and what actions triggered it. So as you are reading cases, remember syllabus and skim, or summary and skim. Always start with the summary, which is also called the syllabus, and then learn how to skim effectively, which often means that you just let your eyes skip over a bunch of legal citations and flowery language. So you're going to want to skip the clutter and skip that flowery language. So here on the screen, here's a direct quote from Miranda v. Arizona, which is absolutely cluttered with citations. That makes it hard to read. Here's the same language, but without all of the legal citations cluttering up the paragraph. It's easier to read, but it is still a mouthful. So finally, here's the language without the citations and without all of the excess flowery language. It's still a direct quote from the court. I have just cut out a lot of it, and it makes it easier to read. So that's the trick when you are trying to distill cases. Skim, just ignore the citations, ignore the flowery language, distill it to the essence. The other trick is to do a keyword search for hold or holding. In Miranda, if you do that, you'll immediately get the meat of the court's decision, which starts with, our holding is this. Now here is an example of a case brief of Miranda v. Arizona. You'll see that I included the name of the case as well as its full official citation to the U.S. reports. Then I've written out the most essential facts, questions of law in plain English, the holding that answers the question of law, and the court's rationale. Notice that that question of law can be answered with a yes or no, and the holding starts by answering the question with a yes, and then it plainly states the holding. The rationale section is the most difficult to write because you're just distilling many, many pages of a court's decision into what is going to be less than half of a page. But doing this really does make sure that you're understanding, that you have a deeper understanding of why the court ruled as it did. So case briefs let you practice translating this dense legal jargon into plain English. And that's really crucial when you, as a public administrator, or somebody at a nonprofit, or even at a for-profit, when you have to explain what the law says to the public or to another non-lawyer. You really need to translate this legal jargon into plain English. So I'm not going to read this whole case brief to you. I'm just providing it so that you have an example. So if it's helpful, please do refer back to this slide when you are briefing your cases. Okay, finally, I want to really briefly discuss agency decisions. We will get into this later in class, but most agencies have administrative law judges, ALJs, and they preside over administrative hearings, also called adjudications. The Administrative Procedure Act requires that in formal adjudications, ALJs provide a written opinion. That's got to include their findings of fact and their conclusions of law. And unless those are overturned by a court case or a subsequent statute or regulation, the agency decision does set precedents for that agency. Only for that specific agency, though. The administrative opinions of one agency have no precedential value for other agencies. So the USDA does not have to follow FDA decisions. But you can still use them to try to make a point. So if you disagree with an FDA regulation and the USDA has issued an opinion on a fairly similar USDA regulation, you could try to persuade the FDA administrative law judge to adopt the USDA administrative law judge's reasoning. The most commonly used administrative decisions are the Comptroller's General Procurement Decisions, abbreviated CPD. Those are very meaningful for government contractors, as are decisions from BCAs. That stands for Board of Contract Appeals. There is also the ASBCA for military and intelligence agencies. That stands for Armed Services Board of Contract Appeals. There are also a variety of civilian BCAs. This is at the federal level, but it's fairly similar at the states. Some agencies, like the Department of Interior, have their own internal Board of Contract Appeals and other administrative decision-making authorities. Agency citation formats are not always uniform, so your best bet is to Google a specific agency decision and then try to take a look at the agency website that describes its administrative decisions. Agency websites usually have the most recent versions of agency decisions. You can get to some administrative decisions via Nexus Uni and Westlaw, but it's not all of them, and it's not necessarily the most intuitive method of finding them. Okay, if you are still with me, then congratulations on making it to the end of a very long and detailed legal research lecture. Like I said at the beginning, if you can remember back that far, my main goal is to walk you through the process with these screenshots, which you can then use as a step-by-step legal research guide for the rest of the semester. So, due this week, we've got discussion 2. It is about those legal research exercises that have been embedded through the lecture. You are going to have to make an initial post before you see your classmates' posts in D2, but you don't have to have all the answers up front. It is fine to help each other. Our D2 discussion board is a collaborative space, so do help each other find the right answers. Also due this week by Sunday night is your first case brief. I'm having you brief Loving versus Virginia because it's a groundbreaking Supreme Court case, but also because as Supreme Court cases go, it's real short and to the point. If you were to paste the opinion itself into Word, it is only 4 pages long. Now, just because a case is short and fairly concise doesn't mean that you're not going to have questions. So there will be a collaborative discussion board available for Case Brief 1. You each have to submit your own case brief, written in your own words, but feel free to help each other bounce ideas around. I will also be on hand to answer questions, although I'm going to delay a bit just to see if somebody else wants to step in. All right, thank you for listening. Have a great week. I will see you on the discussion boards.